Aren't we past the speculation and conjecture aspect of this, though? I mean, the original and the core of the financial allegation was that there is a relationship and that money has changed hands. There's maybe still an open question of where the ledger stands, but I think it was conceded that that balance could run in one way or in the district attorney's favor.
It was a calculated determination by Ms. Willis to prejudice the defendants and their counsel. How so? By making an issue out of the fact that the person that was challenged in the Roman motion was black, without telling the public or the church members or anyone for that matter that the reason that Mr. Wade was being challenged was not because he was black, had nothing to do with race. It had to do with the relationship that had been alleged and later admitted to. She could have said the facts of the matter. Instead, she misstated what the situation was, took advantage of the opportunity, an ethical violation, and the ethical violation makes it clear that you must refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused. Can you think of anything more that would heighten public condemnation of the defendants than alleging that defense counsel and the defendants were making their motion based on race and religion? That's as bad as it gets in Fulton County, with all due respect.
Deserve a DA that won't have sex with his employees.
I didn't sexual assault anybody.
Who's Anna Rodriguez?
Ask that again, please.
No doubt. Hugging, kissing.
To have inappropriate contact because we deserve better.
I certainly will not be choosing people to date that work under me.
What is good, YouTube family? It's your boy Rashad. We back again with the Black Anomaly Rising channel. So I gotta talk to y'all today about this Fani Willis final hearing. Okay, supposedly. Now, the way this went, we really don't know if it's the final hearing because it ended with Judge low-key being a little P word and saying, well, you know, I'm going to think long and hard about this. You know, I'll let you guys know in hopefully the next 2 or so weeks.
I think has been very much made clear by the argument and the made today is that there are several legal issues to sort through, several factual determinations that I have to make, and those aren't ones I can make at this moment. And so I will be taking the time to make sure that I give this case the full consideration it's due. I hope to have an answer for everyone within the next 2 weeks. Until that point, if there are any other issues that come up, counsel can reach out, and we'll have an order posted on the docket. Thank you all.
Now, I got mixed feelings on this, but overall, I do think that it is not looking good for Fani Willis. She might be toast. It might be it because, and I'm not just saying that for the sake of the video, I'm saying this because he was very, very critical of the state prosecution, and their defenses were basically weak. They're very weak defenses. They're basically trying to pretend like, well, we know that there's a bunch of signs, like 11 and a half, 1,200 different signs that, you know, Fani Willis is guilty of what is being suggested and, you know, what the motion is suggesting. However, since it wasn't definitively proved like you would in a criminal case, then basically the whole thing should be thrown out and the motion should be dismissed. The judge did not seem to agree.
There were a number of these cases that seem to exclusively rely on the appearance of impropriety.
Right.
Well, they acknowledge that there's some ambiguity here, that sometimes Whitworth gets cited to Ventura, and we've got this quote that comes up where it's just they only cite to an actual conflict that must be involved. They acknowledge the ambiguity. You're saying there's no ambiguity whatsoever.
I am saying that, and why I am saying that, why I would submit that to the court, is in all of those cases, they do reference the appearance of an impropriety, but they reference that because they also find there's an actual conflict in each one of those cases.
So your position would be, your review of the case law, there's never been an appellate opinion that relied only on an appearance of impropriety?
As it relates to a prosecutor or district attorney, yes.
And I think some of these are just relating to kind of aspiring for broad language about standards to prosecutors. So point taken there. But if there are more, all right, keep going. And amusement sales. Greater Amusements is one of those. You refer to the appearance of conflict as dicta. Why do you think that's dictated? I think the quote from that one is, it guarantees at least the appearance of a conflict of interest. Why is that dicta? It seems very central to the holding in the case.
Because I don't disagree with Your Honor, but in that case, an actual conflict was found, and the appearance.
They didn't find that.
I would disagree with Your Honor.
Now, where the state prosecution really got smoked here, which I thought was preposterous when I saw them try this, and, you know, I'm glad that, you know, Michael Roman's defense fired back on this, but they tried to say that, well, the defense didn't really question Nathan Wade enough, and that therefore means that they did not believe that they could breach what Nathan Wade has said or make him look like he was lying or anything like that, even though it was already proven that Nathan had lied, for example, in his divorce decree, and the fact that the state prosecutors tried to prevent Nathan from speaking due to attorney-client privilege, and even when it wasn't attorney-client privilege, just kept doing objection after objection after objection. And like I said, Michael Roman's defense called this out. They didn't let that slide.
And the assertion by defense counsel is that Mr. Wade and Ms. Willis began a relationship right after they met in October of 2019. What's interesting and what's telling is that Mr. Wade's handset doesn't once appear in anywhere near the area of her South Fulton home, but they're dating, but they're in a serious relationship. And if you were to believe what the defense counsel says, that they have been in a relationship from October of 2019 up until she moves in April of 2021. So, you know, a year and a half or so, but he never once enters the area of her home. But they want you to believe that that's a lie, which is why counsel for defense continued to press District Attorney Willis and Mr. Wade as to whether he had ever been to that South Fulton home. Well, this corroborates that that was not a lie, that he had never been to that home, and it's more than suspect if you've been in a relationship, as they claim, for all this time, but never once went to the house, other than the one conversation that allegedly occurred between Mr. Wade and Mr. Bradley. And I would submit to the court that that conversation never occurred. That would be the state's contention. And how do we know that? We know that because that conversation was not confronted, or Mr. Wade was not confronted with that conversation. And that is evidence circumstantially, and I'd even say direct, as to that conversation not existing. Because based on the representation made by defense counsel, it would be clear that that would be a conversation that would have been relayed to, because it wasn't privileged, as Your Honor found, that would have been relayed to Ms. Merchant. And if that conversation happened, you better believe that would have been a conversation that defense counsel would have confronted Mr. Wade with and against.
State somehow makes an argument that we should have asked Mr. Wade questions about his relationship and his communications with Mr. Bradley when they objected over and over and over. And Wade's counsel objected over and over and over, claiming that everything that Bradley was told by Wade was attorney-client privilege. Your Honor made determinations thereafter to Bradley. We didn't get the opportunity to call Mr. Wade back to the stand. So to claim that you can't impeach him because you didn't ask him when they objected to us asking him is obviously a false position to take, as disingenuous as it can be. Now, if the court wants to open it up, we'll be more than happy to call Mr. Wade back to the stand. But as the record stands, there could be no confrontation of Mr. Wade when both his counsel and the state are arguing that it shouldn't be done. No one knew that there was a relationship between Wade and Willis, according to Wade and Willis. Not a soul was ever told that they were dating or that there was an intimate relationship, ever. They concealed it from all parties, from Daddy. Daddy didn't even know they had a relationship. Suggest that somehow in the beginning of 2021, January to whatever it was into April, that they couldn't have met in Hapeville, they didn't meet anywhere that would allow the public to see them. That's the reason why they were meeting at Yertes, because no one else was ever there. Remember the testimony? Who else was there besides Mr. Wade and Miss Willis? Both of them agreed. No one ever went there except them. They didn't go to where Daddy was in Miss Willis's house because Daddy was there and Daddy would know. No other prosecutors knew. No one knows except who? The one person that knew was Bradley and Yerty. Yerty was the best friend at that time of Miss Willis, and Bradley was the partner of Wade.
And like I said, the judge was pretty freaking critical of the state prosecutors because to me, it seemed like he wasn't buying it based off of the case law that was presented. And their arguments just were not strong in support of Fani Willis. They tried to defend the whole thing with the cash, and the judge just didn't seem like he was buying the fact that you had to prove definitively that there was a conflict versus the appearance of impropriety. The judge definitely seemed like he was more so on the side of the appearance of impropriety. Now, there is still some evidence that was technically not even submitted into the case, which the way that they have this set up, I'm not really sure why they have it like this. I can see you don't want people to just keep submitting new witnesses, submit new evidence forever, right? I understand that. But at the same time, I mean, just hearing that there is cell phone records to say that, well, we don't want to admit those in the evidence yet. You know, let's just see what I think about it, and then I'm going to decide later. That sounds ridiculous to me. I mean, this is data evidence, and the freaking prosecuting attorneys for the state tried to argue like, oh, this is data driven, not like voice driven and stuff. I was like, dude, you need to go sit your whack ass down. Like, you don't know what you're talking about. Clearly, Fani Willis is guilty of what the motion is claiming. So is Nathan. And they're lying to cover it up. And for some reason, Terrence is doing the same thing now, which I'm not exactly sure why he would do it. There's lots of theories that maybe he was threatened, or, you know, maybe they're going to come after him. Maybe they already have people after him. So he's kind of like, okay, if I will dial it back, y'all going to leave me alone. I don't really know. You know, maybe he might get pulled into it financially to help benefit him too. You never really know. It's all kinds of different theories that are out there for why this fool Terrence is acting the way he is. But the one theory that I know is wrong is the one where they say that he was telling the truth in the courtroom. Because Mr. I cannot recall this, I cannot recall that. Oh, you know he was lying. He seemed to recall a lot in those text messages, stuff that was later proven to be true. So we'll see what the judge has to say. But I'll tell you right now, my opinion is it does not look good. A lot of people said they felt like he was kind of siding with Fani Willis because basically he let her run wild like a wild animal in the courtroom, which he did. But it seems like he was aware of that criticism because the next time he was in the courtroom on day 2, for example, and in the Terrence Bradley hearing, and now in this presumably final hearing, he seemed like he was pretty firm, and he kind of was looking at this evidence like, man, I know these fools are guilty and lying to my face. Maybe it got under his skin that he was being called out and they're lying to his face, trying to think like, well, hey, you know, either the judge is stupid or he's on our side, so we're going to get away with this. And it doesn't look like the judge is going to have it. But there's no way we can really know for sure. A lot can happen in a couple weeks, which is why a lot of people don't like the fact that he said that, because, you know, he could forget stuff. I mean, new stuff could be introduced over time. Not that necessarily takes away from what the Michael Roman's defense is saying, but you never know what might happen. Maybe somebody threatens the judge. I mean, I'm sure that he's probably getting threats about this, at least to some extent. So you never know how that can sway somebody's opinion. Also, he's an elected official, so you never know how that could sway his opinion either, you know. But I will say this, based off what I've seen, I personally think that based off what I've seen, I don't know this guy's whole history, his life history, based off what I've seen from the judge so far, he seems very critical and does not seem like he buys all of this stuff about paying cash and we don't have no proof that there was any deposits and all of this. I don't think he buys that at all.
Aren't we past the speculation and conjecture aspect of this, though? I mean, the original and the core of the financial allegation was that there is a relationship and that money has changed hands. There's maybe still an open question of where the ledger stands, but I think it was conceded that that balance could run in one way or in the district attorney's favor. Is that contested?
Yes. What's not contested is that a relationship did develop between
and that purchases were made back and forth. That's the state's position.
That it's the state's position, but they were made back and forth. The purchases were made back and forth, either to equal the money that was spent by one party or the other, and if that wasn't done, cash was exchanged in order to equal the costs that were paid by either one of the parties.
Right. But that's a facted issue, whether it was, split even, or whether it goes a little bit one way or another, or whether it's all the way $10,000 one way or another. That's a facted issue as a result of the hearing, but it's no longer just the theory that money changed hand is no longer speculation or conjecture.
And it seemed like he also doesn't buy the fact that it needs to be definitive proof. Seems like the appearance of impropriety is enough. And that's definitely the side he was erring on as of today. Might he change his mind tomorrow and before he gives his final ruling? Absolutely. We shall see. Drop a like on the video. Subscribe to the channel if you're new. I appreciate you watching the Black Anomaly Rising channel. I'm out.
Because not a single story from the media reported anything other than Fani Willis accused the defense and defendants of being racist. Now here's the common sense part of this. If you follow the state's position on forensic misconduct, Fani Willis could all day long talk about race. She could say the defendants, I'm not saying they're guilty or not guilty, but they're racist. They're racist. They're racist. And according to the state's position on forensic misconduct, that wouldn't be a problem.